certificate of non-reply. Then you send them a notice of default.
Right.
And they have 10 days.
Mm-hmm.
At the end of that 10 days, then you take a copy of all of these things that you sent them certified mail, plus your 3 certificates from the notary.
Mm-hmm.
You go to a federal court and you ask for an adjudication of the matter.
Okay.
And in the federal court, well, it's a federal claims court, not just any old federal court, but a federal claims court. And in an adjudication, the only thing the judge can do is say yes or no.
Mm-hmm.
So, given the overwhelming amount of evidence, he doesn't have much choice but to say yes.
Mm-hmm.
At that point, then you go find the U.S. Attorney General in your state, and you say, I need help collecting this.
Great. Do I need a certificate of dishonor at the end of the process?
No. This is a straight administrative process.
Great.
Keeps the notaries from objecting and saying, oh, I can't do this, I might get in trouble.
Yeah, I've got a notary that'll work with me, so that's no problem. I've already done this.
In this particular case, it takes all the burden off of them. All they have to do is say yes or no whether or not they received mail in your name and their address.
Right. Good. Okay, and you'll be posting that?
Yeah, I will be putting that up in a folder in the file section in the next day or so.
Excellent. I'll give it a run.
Along with a set of instructions.
Yeah, I'll give it a test.
Mm-hmm.
That's
the examples I want to put up there, they refer a tax case, so they're going to look a little bit funny. You're going to have to adapt them as you need them, but gives you a really good starting point.
That's great. I really appreciate that.
Louis, this is Greg. Is that just a slight is this a variation on what's in New Beginnings with that process?
No, this is an entirely different process. This is a totally administrative process. In the New Beginnings, you're dealing only with notaries, and you're doing it in a common law tribunal. This is fully administrative and winds up in a federal court of claims. And a federal claim takes precedent over any state claim. So it's extremely powerful.
That's great. Well, I still have a court case coming up August 5th with a felony charge for forgery or worthless check. And I'm going to use the procedures that we've talked about, Jack's talked about, and Cindy. But I think what I need to do is try to get my no-cost bond to replace the cash bond. Do you have any suggestions? I did call the court, asked them if they would issue an own recognizance bond. And they said no, they wouldn't do that. I'd hire an attorney.
Okay, the bond from Jack, which is basically a rework of Rice's bond for a court case.
Right.
Just take that, fill in the case numbers. And then as far as the matter of actually going to court, and use Jack's method of declaring, well, actually it's a combination of Jack and Rice. Rice started it and Jack has adopted it. You declare yourself competent and everyone else incompetent, and you demand equality under the law, and you declare that all the facts in the matter are true.
Mm-hmm.
And you give the judge the bond to cover all costs, losses, damages, or anything else in the matter. I would also use Jack's letter rogatory and his letter of negative averment.
Mm-hmm.
And between all of those, the judges and the attorneys seem to be running.
And you wait until you actually show up in court to present those to the judge?
No, you send a copy of the letter rogatory and the letter of negative averment to the clerk of court and to the judge via private mail.
Okay.
At least 3 or 4 days before the court case.
What do you mean by private mail?
Well, not certified, not registered, in other words.
What about courier?
Courier would be fine.
Or UPS.
Or UPS, or walk up there and hand it to
FedEx,
them.
FedEx, yeah, that's right, yeah.
Yeah, or walk up there and hand it to them yourself.
I'd like to add something to what you just said, Louis.
Okay.
I was listening to Rice today, and it was in his first tape of the 4 tapes that were on June 18th. And in there, I made a note of this as I was listening to it. He said, when you're in court, you say, I am going to accept this as true.
Right.
As is the operative word rather than is true. And I return to you for discharge and closure. And you may want to listen to this tape, and I'm just starting on the second tape right now.
This is Jack's 616 tape?
No, this is actually Rice's.
Oh, Rice's. I don't have Rice's most recent one.
Yeah, it's just uploaded. Yeah.
Doug posted it.
Oh, okay, I haven't got there yet.
That's okay.
Jack says all facts as true.
As true. As is the operative word that I picked up.
Okay.
Yes.
Yeah. I think in his written statement, in his letter rogatory, he actually says all facts are true. Let me go double check that.
Yeah, you're right.
The letter of rogatory. What does that mean?
The letter rogatory?
Yeah, what does that mean?
It's up in the attorney contract folder.
Okay.
Doug, what happened to the affidavit of negative affirmation that was up there?
I have not transcribed it yet from the tapes.
Well, I've got a copy. Why don't I post it up there?
Oh, great.
Where did I get mine if I didn't get it from you?
Well, I want to rewrite it because there's more stuff that needs to be in there.
Oh.
Since we're on the topic of legal issues or criminal issues, I'd love to tap the collective brain trust here. I've had Criminal Investigation Division of IRS after me for, well, the audit's been going on for 2 years, and the CID's been involved for 3 or 4 months now. And they've never told me I owe them any money. I hassled the agent so much and filed a formal complaint against her. I'm sure that's why she referred it to CID. Can anyone think of a way to send them a bond in advance of them sending me a bill to make the whole thing go away?
No.
Okay. Well, I couldn't think of a way either, so I was just...
Doesn't Rice send one that's open? Let them fill it in what they want?
Well, but if they've never presented anything to him, it's a little hard to do. Because you don't know the proper person to send it to.
Okay, good point.
Yeah, did you ever get a deficiency notice that has an amount and...
Never. That's the thing. It started as an audit. The audit went for 2 years. And I ended up, making the agent's life miserable and finally filing a formal complaint. I used IRS code busters at the time to decode my IMF and send a bunch of letters in, and then kind of departed from them and went down with some Eddie King stuff, et cetera, and then she referred it to CID, and since then I've, demanded delegation of authority, 33 questions, and finally filed an affidavit on her. She hasn't contacted me in a long time, but I do know she's working behind the scenes talking to my old accountant. So it's still going on, and I'm sure it's going to raise its ugly head someday. And I was just trying to figure out a way of saying, here, take it, go away.
Now they're just trying to build a case on you.
Yep. And of course, all this other activity I'm involved in only makes them all the more interested in building that case, since I am one of their terrorists.
Yeah. Excuse me, Louis. The gentleman from Florida, before we get too far from that subject, this is Benny. What happened to me was almost an exact duplicate, and I would like to communicate with him privately. What an email address or something to that effect?
I'm in the database as Joseph.
Okay. And I'm Benny.
Great. Yeah, love to.
Hello, this is Tom in North Carolina. The guy that was just speaking about the IRS issue, the Rock Group is doing some neat stuff with that. And what they're doing is sending a 1040 with giving him a limited power of attorney to fill the thing out for, basically he's asking for an assessment. And the way he's doing it is, please give me an assessment. this is Jose Martinez's information. Say, please give me an assessment. And by the way, you sign under penalty of perjury and everything else that everything you have is under first-hand knowledge and stuff. So you're asking him to basically do an affidavit. I saw some Jacqueline information that was very similar to that. It's in the form of, please help me. I don't know what to do, and here, you fill it out for me because you know how it works, and that you don't have any first-hand knowledge or anything else. And that's a good way. Jose has wonderful, and if you want them to do it, you can contact him through the Rock Group, and he'll do that stuff for you, I think. Or Dan Benham will. And
well, that's fine if you know who to send it to, but if he doesn't know who in the IRS...
Well, he was talking about some lady that was, he was pressing things against, so...
Well, she's just a CID agent doing a criminal investigation at this point.
Well, I would think anything that went to your file that you had put into your file, you can get a copy of the file, shows that you made a good faith effort to take care of whatever liability they say you had.
Exactly.
So go to that and start to fill out. I just know what it is. It's the 1041 with a limited power of attorney and saying, please, I don't know what to do. I can't figure this out. Would you please do this for me? And by the way, do it under your IRS codes and regulations that say you have to do it with first-hand knowledge and all that stuff. And it really seems to be very effective for him. In fact, he's almost 100% with his success rate. Again, Dan Benham can help you with some of that information if you contact him if you need more detailed information than what I gave you.
And as far as sending, I always send to the district director and then whatever agent has sent to me. So you do, and it's that notice to agent is notice to principal and vice versa. So your district director would be one place to send the query. Help me out. And I'd CC the agent.
Okay.
But that's really good. What he just told you, they won't give you the assessment. They can't give you the assessment. We learned that, and who did we learn that from? Rice?
Mm-hmm.
It goes back a few months on our conference call.
Yes, it was Rice. Yeah.
And they cannot give you an assessment. And so they're playing these crazy games and driving us crazy, and all you've got to do is turn around and say, give me the assessment.
Well, I got an assessment. It was entitled a proposed assessment.
Exactly. That is not an assessment. But
Well,
you
then
can, Jan
This
taught me,
assessment.
excuse me?
Respond to the proposed assessment, which I did with a Rice bond, and it's been 6 weeks and haven't heard a word.
Oh, because you're on good track there.
You accepted the proposed assessment.
You turned,
You contracted with them. You accepted their terms.
and he discharged it with the bond.
Right.
I will be happy to tell you about any of mine when it happens because I have been garnished by them. Actually, a disability payment's been garnished by them. Even in their code it says they can't do this, but they have done it. And I sent them a bond May 10th. So I've been looking every month, and I haven't had a chance to look this month yet to see if they're going to continue to take the stuff out. But I'll be happy to share any success when it comes. I'm hoping it'll come soon. So I'll let you know as soon as that happens. Stay tuned, you know. So anyway, it was sent to Puerto Rico. But that was 4 weeks before we heard that they weren't taking Puerto Rico stuff. So we'll see.
Well, if you send it to the IRS, they don't have to send it to Puerto Rico. They are Puerto Rico, so. All right, so the suggestion is there's a 1041 with limited power of attorney.
No, do your...
Hello, is somebody going to cut off?
I think
I'm sorry.
1040.
It's 1040. 1041's the trust thing we were doing. That's
Right,
different.
okay.
That's a
1040
different thing.
with a limited power of attorney.
And just say you want your help, please help me with this. And please do it under your IRS regulations. If you want more detailed information from Dan, they've got it down to a science. It's very precise. Dan Benham of the Rock Group.
Rock Group. Okay. All right, I'll try and get a hold of Dan. Thank you. That's why I wanted to throw it out there. I have enough stuff hanging over my head. I don't need more.
Okay, I wanted to give Frank Moore a chance to say anything of Rice that Rice might have said Wednesday, last night.
Doug?
Yeah.
I hate to be what would I say, a non-life of the party here, but
Yeah.
we had errands we run yesterday, and my knees were so hurting so bad last night we didn't go.
Oh, okay, understand. Yep.
So I apologize that we fully intended to go.
Yeah, that's fine. No, I understand.
What's the source of the pain in the knees?
Well, it's a combination of arthritis and car wreck I was in 4 years.
We may be able to help you with that.
I need to get the cartilage is damaged beyond even I can't even get in the study. It's degenerated so bad. I really need to get surgery on both of them.
No, you don't. We've actually regrown cartilage in knees.
Who's talking and what method?
It's called a Lakovsky multi-wave oscillator.
Yes, I'm interested.
Developed in 1921, and I've now got 3 medical clinics using them, and they're seeing the exact same results that we've seen outside the medical industry. Practicing privately, if you want to call it that. So, I guess I need to put my database information up there, but it's Ed, and
Ed in North Carolina.
Ed in North Carolina. So I'll put that up after the call or while we're on the call. But my wife had all her cartilage out of her knees when she was in high school, and we've actually regrown it. Her knees are as smooth as mine now. She's been pain-free for 7 months.
Wow. Thanks.
So no reason to suffer. There's ways around it without surgery.
How's it do with brain?
We've had luck with MS, Parkinson's, trying to think what else, cancers, heart disease. What it basically does is regenerate tissue of any kind.
You direct it at a specific body part? Is that how you do that?
Nope. It's a whole body treatment.
Do you have a website on this?
www.stopthetyranny.com. It's kind of a work in process because we've been fairly busy with the machine, but you can get my email up there too. And I'll email some stuff out to you.
Yeah, this is Doug. I recommend you getting in touch with Ed. I've seen the machine, and my wife's been on it too.
Something that, well, they killed him. He was killed in 42 because he came to the United States and his stuff worked. So, run over by car in the streets of New York City. Sorry for that little deviation there. Go ahead.
Okay.
No, that's great. Thank you.
Yep.
Is that similar to what Royal Rife had also?
Don't get me started on Rife. I'll be happy to explain the physics of why Rife doesn't work that well, and his research was great.
Okay.
But the physics is against it working the way they're doing it today with machines.
Okay. How do you spell tyranny?
T-Y-R-A-N-N-Y.
My brain was blank.
Live it, learn it, love it. We're in the middle of it.
We're going through it, though. We're not staying there.
That's right.
This is Joyce in Taos, and I wonder if I could take just a few minutes and kind of go over some ideas I have on my foreclosure thing.
Yes, please. I have some ideas, too. There's a fellow that's got an auction on August 7th, and I've got some ideas I want to throw out, too. So go ahead, Joyce.
Okay, just from listening to tapes and calls and learning and stuff, I had sent a letter to the attorney 6 weeks ago requesting a payoff. The mortgage company would not give me one. They said to contact the attorney, and he has not responded. I have a feeling that he probably, because he's up pretty often, or his firm is, checking his house on, they seem to be the main foreclosure attorneys here. And he may have run across my copyright, etc. I have no idea, but that's just a thought that I have. But on the thing about firing the attorney, I was thinking about doing that, and hearing that, okay, with an affidavit, to get information into the court, this is just some of the ideas, and I'm just going to get feedback. Since equality, under the law is paramount, then an affidavit stands as truth, and that unless negated, like point by point. So I was thinking about doing an affidavit firing the attorney, sending a copy of that to the court, filing with the court, and also an affidavit in it saying, yes, I signed this note, et cetera, and then put the negative reverment in there saying that on the 4 different points that I filed a suit on. And to show that, and then possibly a copy of the accountant's opinion that I got, and I don't know if that would stand very much, and also copies of the Fed publications, and because I received, I guess, about 15 of those, and also a copy of the UCC and the copyright and the power of attorney. My idea was just to put all of this stuff in court so it would be on record, then firing the attorney. And I'm realizing, too, that still the, hoping that the processing centers open up and we can get the bonds. So if nothing else happens, or this fails and they don't just drop it, still go ahead and discharge it with a bond. But see, I'm in 2 different, I'm kind of going on 2 different paths because I did file suits on them, and then now I'm learning about the bonds and all this, but the attorneys haven't contacted me or anything, and it's been 2 years. I mean, I heard from them like 3 months ago, but and maybe I don't know. I think if I just sit here, maybe it'll go away, but I know it's not. But I feel like I need to do something.
Have you done any form of discharge yet?
No.
Okay.
So.
I'm getting ready to go through this. I sent I'm going to use the word, closed account check to my mortgage company 2 months ago, and they never did anything with it. Now they sent me a notice of foreclosure. Now I'm going through a notarial protest because they didn't do what they're supposed to do, but you're going through a foreclosure simply because you couldn't make the payments, I guess?
Right.
Okay. Well, I would certainly get a bond or something out to them so that you could start a notarial protest as well for not honoring it. Or actually use Lewis's process. Sounds like Lewis and I are going to be using that as guinea pigs ourselves as well.
The administrative.
Right, the administrative. If you get a bond out to them as a payoff, and then they dishonor it, then you go through the administrative process to basically get a judgment against them, which is the reconveyance of your property back to you. And if you want, Rice says you can leave the bond blank, but they fill it in, so you don't have to have a payoff amount.
Okay, and see, here's the problem, too. I don't even know who to send it to.
They've had an attorney contact you, right?
Correct.
Send it to the attorney. If they're the last one to contact you, send it to the attorney, send a copy, make sure it's stamped copy, there can only be one. Send a copy to the mortgage company, to the president of the mortgage company.
Okay, see, here's the problem, too. I contracted for the loan with Superior Bank. They went into receivership. They transferred it to LaSalle Bank National Association. Then I never heard of LaSalle Bank until I received the foreclosure notice. And then that was when I got in with due process, and I filed a countersuit. Then a few months later, I start getting collection notices from EMC Mortgage. So the last thing I got from the attorneys, they're saying that Superior Bank, LaSalle Bank, and EMC Mortgage are all, they didn't say they're all the same, but when it refers to one, it includes all of them.
Fine. If you got an address wrong, send a copy to all of them. Record a copy of the bond contract, etc. Send a copy to your clerk of court and your sheriff, and the state comptroller and your governor, notifying them that the debt is discharged. Get that all out there. They have, what is it, Lewis, on the bond contract? 21 days to notify you they've discharged the debt?
depends on which state you're in.
I'm in New
It
Mexico.
varies from state to state.
I'm in New Mexico.
Okay, but as soon as that time period lapses, then you start your process and get a judgment against them. The judgment you can record with a UCC-1 against the mortgage company, the lawyer, everybody, which binds them up. You can't go anywhere. They can't go into court and get a judgment against you because they haven't satisfied your judgment against them. You can liquidate them. That's what I'm doing. That's the process I'm going to go through. Because I basically forced the mortgage company into that point.
Okay. Well, see, they filed foreclosure on me, and then my response, I counterfiled on them.
Okay, but see, you're going to lose in court.
Right.
I mean, they're the plaintiff. They pay a lot more taxes than you. You're going to lose if you go down that road in court.
Right.
So don't fight. You're in dishonor. You're disputing. You're giving the court something to fight about. So therefore, send them a bond. Give them their 14 or 21 days, depending on whatever it is in your state. If you've got the time, give them 30, you know. But if you don't have the time, then you're going to have to move quickly and then start the process and get a judgment against them for dishonoring your presentment.
Okay, so who do I send the original bonds to?
Send it to the attorney. If they're the last ones you heard from, send it to the attorney.
Excuse me, this is Gary up in New Hampshire?
Yeah.
Yes, where would you get these bonds?
Somebody else will have to handle that one.
Yeah.
Gary, you're just joining our group, I take it.
Huh?
I take it
just saw a while ago.
New member in our group.
Yeah.
Okay. Bonds are a long discussion. We have a folder in the files section.
Yeah.
You know where the files are on the Yahoo group?
Yeah.
There's a folder called Bond of Discharge. And there's instructions and prerequisites and templates and everything in there.
Okay.
Yeah, Gary, I'll get with you after the call.
Okay. Doug?
Yes, this is Doug.
How you doing?
Okay.
A minor point, didn't we say we will not send to the governor anymore, or if so, it's strictly the office of the governor?
Well, we're not going to send anything to the governor unless they are violating the law. Now, if we get a judgment against them, yeah, we probably ought to notify the governor that we're going to foreclose on one of his big taxpayers.
Okay, got it. Thank you.
But it would be much more effective to notify the Office of the Comptroller of the currency in that state, because they're the ones that are ultimately in charge of the mortgage company and the banks and everything else.
Okay, so I think her first bond, she's going to notify the comptroller of the state because they're not in dishonor. If they dishonor it, then when the copies would go, perhaps, to the governor.
Yeah.
Once you get your certificate of protest, correct.
Okay.
But she needs to move quickly because that process takes, 30, 40 days.
Right.
And you need to have that, and then once you get that, see, you can put that in the evidence file of your current case, and do an amended complaint, where you're just looking for the judge to acknowledge your claim. Is that?
Confusing enough.
Yeah, I was just wondering, she should probably also just drop her counterclaim.
Oh, yeah, definitely.
Yeah.
That's what I was wondering.
Yeah.
Just abandon it, okay? And don't let it distract you because, believe me, I've been there with banks, etc. You're going to lose. I mean, you won't even get to a trial. There will be a summary judgment hearing. You're toast. They have a judgment. You're done.
Yeah, she should notify the court, though, that she's abandoning the counterclaim so that they take it off the books.
Correct.
Okay, how is that actually done?
Just go to the clerk of court and tell them that you want to abandon it, and they give you a little piece of paper to sign.
Okay.
Yeah, but this other stuff, you have to move quickly. Get your bond. Have you done your power of attorney and all the other stuff to do your bond?
Yes.
Okay. Get your bond out Monday morning.
Okay.
What's wrong with Saturday morning?
Well, that's true. The post office does work Saturday. Get it out Saturday, You do express mail there in a day or two, so you don't lose any time. Get your clock running and hit it on 10-10-10. Lewis, what would you tell her? Would you do a Notero protest today, or would you put her onto our new thing, or?
Well, the notarial protest saves her from having to spend the time getting it through a federal claims court.
That was my thought, but I wanted to defer that to you.
Yeah. So,
you can always actually go do that second process if you want.
Sure.
If you don't get satisfaction and release from your current claim, you could follow right back up with the process. And actually, again, that's why Lewis and I would probably end up there.
You could really do both of them in parallel.
That's true, too.
Right.
Yep.
And I'll have to get you a new bond, Joyce, because the one we have now is, well, it's tailored for the processing center, but we need to have a version of that in this emergency.
Well, there should be one up there for use with a court case or the IRS or anything like that. Did you take that down?
No, it's still there, but I wanted to adapt it, improve it with the...
Make sure that has the Washington, D.C. address, if that's what we're doing.
Exactly, and I've done that. I'll have to upload those tonight, I guess, but...
Hey, Joyce?
Yes.
Did you get that stopattorney.com website I put out? There is my email address there if you want to join. I mean, I'm going down this road. That way both of us won't have to take up Lewis's time.
Okay, and what is your name?
Ed in North Carolina.
Yeah, okay.
Oh, come on, Ed. Tell her your last name.
Waller. I'm not shy. Ed Waller. Hey, the government monitors my phones, my cell phones, my emails, you know.
Yeah.
Who are you hiding from?
Yeah.
You know?
Yeah.
They knew mine, I know.
And the email address directly is ewaller, EWAHLER, @bellsouth.net.
This is Mark in North Carolina. Where are you at, Ed?
Asheville.
Oh, you're up there, too. Okay, with Fred.
Yeah, we've got quite a few people in that area.
Yeah, we've got a Fred up here who's a good friend of mine, too, who's very active.
I'm down in...
I have a question about the bond. This is a quick question. If you get something from a third party versus a first party, does it make a difference in how you use that?
Yeah, you should not deal with a third-party debt collector if at all possible.
Yeah, I think you should send the bond to the company that's the lender, and you fire the attorney and give him a notice of the bond being sent to the...
Is that what you do? You just fire that attorney and then send it directly to the original...
The original party, because the other guy's interfering, and you never...
You just fire the attorney one to the third party?
Fire any third-party intervener.
There's one issue there, Doug, though.
Yeah.
I understand that I guess they've already filed a suit against her.
Yeah, that's true.
Okay, so she has admitted that attorney already. It's too late.
I think you can still fire them at any point.
Sure.
Okay.
If I hire you, I can fire
How
you.
about after a 30-day notice or something like that?
Okay, so you think I should go ahead and fire the attorney and just send this to the mortgage company?
Yeah.
Yeah.
Is the attorney your trustee?
Is the attorney a trustee, did you ask?
Is it a trustee state?
No.
Okay. Jacqueline has a document I came across. It's very beautiful. It's a validation of payoff and an affidavit of payoff request, and it's asking for them to put an affidavit in for payoff. And it's actually a court document. I don't have it in front of me, so I can't quote it verbatim because I just don't have it with me.
Don't get distracted. Send a bond out so you can start your clock running.
Right, exactly. Yep.
Okay, I really enjoyed that document, though. Anything that slows them down would be great, and you can send that to the mortgage company itself. That was another way, if you can't get the payoff, is what you would have the problem with.
Right.
Again, you're documenting a good faith effort to discharge it.
Right. And Doug, I think that was a good idea. I did go ahead and set up a group.
Yes, good.
Individual group.
Yeah, each one of you should set up your individual Yahoo groups.
It's really simple.
Yeah, it is. And then you can upload and back up your documents to that location for you to get from any location that you're at, and also for me to review if you want me to review your documents.
Okay, should we set it up to where, like, you could post something up, Doug?
It's either way. You invite me as a member and give me whatever rights you want me to have.
Okay, I did invite you as a member already.
Okay.
Okay, so that's what takes care of the security issue. Remember way back I asked about that, maybe in an email message.
Mm-hmm.
So there really isn't a security issue.
With Yahoo?
Right. Well, for others to read our material, if we do our own group, our own Yahoo group.
Yeah, you can put them up there, and whoever you want to invite to your own Yahoo group, you can. Yeah, you can make it a restricted or an open. It's up to you.
Okay.
Yep.
So I did send you an email. It's under joybiz@yahoo.
Yes, great. Good. Okay.
Louis, I wanted to ask, when you were going through this new administrative process, what's the track record on that, the history and so on? So for success rate, we already know something or not?
Well, the person that dropped it in my lap Monday said they've had 100% success.
Sounds good.
That when you walk in and hand the federal judge the stack of paper and say, give me a claim, yes or no, he looks at all of it and says, okay.
Okay. Sounds really good.
Yeah. Now, Maria called me and asked me a question earlier tonight that I'm going to throw out to the group to discuss. If you can't find a notary who's willing to receive the mail for you, can you have somebody else do it and then have them swear an oath before a notary? My feeling is that you can. What do the rest of you think?
I wouldn't see why not.
Right.
I mean, an oath is an oath. It doesn't matter who's giving it, whether it's a notary or somebody else, and the notary is just notarizing it.
Right. It's a question of witnesses, right?
Yeah.
Well, somewhere in my files I have reference to something that was passed by Sandra Day O'Connor in the Supreme Court that said that you could notarize your own paper with a swearing thing, and so when I find that, I'll see how to look up the actual law on it.
Okay.
That it's supposed to be, a self-notarization, but I don't know if that would do the job on this.
I don't think it would, since you're going to put it before a federal judge.
Okay.
Yeah, but the issue is then, Louis, is as you put that documentation together, the person who is simply attesting to the fact that no mail arrived can do that by declaration in the form of an affidavit.
Yes.
Right.
And anyone would have to challenge that and say, see, I did mail something, so it works.
Yeah.
Right.
Yeah, that's my thinking on it. So I'm going to put up the standard form for a notary if the notary received it, and if somebody else wants to make up an affidavit to go with it, that'd be great. I'll put it up there too.
This sure makes it a lot simpler for me.
It's really not a bad process. I'm in step 2 of one notarial protest. I'm in step 1 on another. And, once you kind of do them, they start to flow. I've got a notary who's wonderful. I just take the stuff down to her. She gets it in the mail. She emails me back. I did a Excel workbook sheet on all of the certified numbers, and she just fills them in what she received back the day she did it. It's really not that bad, but like so many people are saying, there was really a very emotional post this week from someone who said, you have to follow through. I mean, everybody's complaining that nothing's working, but you have remedy. And if you don't claim your remedy, then who can feel sorry for you? I mean, who could give you pity? So the remedy is either notarial. I learned...
in addition to that, may I add something here?
Sure, please.
You can also use the phone books in your mailing at the post office.
Yep.
That will stamp those, and that's like another witness as well as your notary. So
Yep.
that adds credence to what you're doing.
But Ed, you want to make sure the notary records it in the journal. It has to be in the journal.
Right.
Make sure she's journaling.
Yep.
Okay.
Does she have to keep a journal, Doug, or does she just keep the
No, she's got to have a journal.
Yeah. They have to have a journal.
It's not the certified mailing?
Nope.
No.
She's got a separate book. You make sure she's got one.
I went to
Mine does not. I need to have her do that, yeah.
I went to a seminar a week ago Sunday down in Rock Hill, South Carolina, where we learned a twist on the private administrative procedure. I talked to Lewis about this about a week ago. And it's kind of a blend between the notarial protest process and the process Lewis has been talking about tonight. You really need to have a claim, but in the case of where you've used a bond, if the bond is for X dollars, that would be your claim. That would be the contract they violated. Or you can send out a notice of acceptance of contract and establish your claim. But basically, you send an invoice, you wait 30 days, it has to cook for 30. Then you send out a notice of non-payment of invoice. Then you send out the second notice of non-payment of invoice. Wait, each of these is 10 days. And then with the final notice of non-payment of invoice, you create an abstract of judgment. Take all your copies, all your green cards, all your receipts, record those at the courthouse as evidence on your abstract of judgment. And I've been told, and I'm doing one of these too against a private company, that it is every bit as powerful as a judgment from a court. So I'll let you know how that works. But it's kind of nice you don't even, other than having the notary sign stuff, you're not doing a notarial protest. You're just doing a private administrative procedure.
That's great, Ed. Thanks.
That's good for going against somebody who's violated your copyright or quiet titles, which is another thing we're doing. So I'll let you know how it works.
Now, I've got somebody that's in New Hampshire, Gary, I think he's on the phone. He's got an auction on July 7th. So we're under a crash course here to get him up to speed and to get all the documents ready for filing. And what I'm recommending is get the notice of competency document, the notice of defect, the notice of acceptance of your offer to contract, the power of attorney and the copyright, and the UCC1 is, of course, all done, a bond to discharge the debt, and an affidavit ready for witnesses at the location to sign for anything that occurs, especially when you give the people that come, you're going to give them an offer, a notice of acceptance of their offer to contract with you, each and every one of them that comes there, and you're going to give them like 72 hours to send back a notice of withdrawal of offer to contract. Otherwise, they're binded by the terms and conditions in your acceptance of their offer to contract. And then probably also have a notary there to maybe actually serve the documents and have someone videotaping everything that goes on. So
I got that all together today. Got my notary and a camera. Someone's going to be there and video the whole thing.
Okay, great. And what you want to do is be in complete honor and actually welcome these people. But you're actually...
I'm buying coffee.
Yeah, exactly. I was thinking get donuts and coffee and really have the completely opposite attitude that they're expecting. It'll psych them out completely.
Now, he hasn't used a bond previously?
No, he hasn't had a chance yet. So he's going to have a bond maybe there or send out maybe Saturday if he can. I don't know.
Yeah, but make sure you either have your UCC1 or your copyright power of attorney in place before you write that bond.
Exactly. Yep. Right. So that's where we're going to try to pull it off here at the last minute.
On that bond, I'm not that caught up. Are we also supposed to have that affidavit recorded at the county? Wasn't there an affidavit that goes...
Affidavit in support of the use of the bond.
Yes, I've got that.
Okay, right. So we have to have that in as well before doing a bond, right?
I recommend it.
Yeah.
Okay.
I suggest you do.
Included, yes, because that gives that's your negative averment, saying that they would have to bear the burden of proof of proving that wasn't an acceptable instrument.
Right.
Got it. Thanks.
Okay. And Doug, you have a copy of this, or can I get a copy?
Yeah, it's in the folder. It's in the bond of discharge folder.
Hey, Lewis.
Yeah.
I have a question, and I know it's a little bit different subject about the private checks. And I know that Cindy was doing something different that was with Droid regard to the EIN number and then a routing number instead of just a regular closed counted checking account. Is that something you're, because it goes directly to John Snow, is that something you're looking at in your research here, or?
Right. I'm trying to get everything in place, all the forms, the contract with Snow and everything, so that people can use the private check. But
as opposed to using the EIN number in place of the routing number?
No, you do not do that. They have to have some way to track the check. And so it has to have the ABA number on it.
Pardon me?
They have to have some way to know what account the check is on.
Well, it has your accounting number, but then it goes to the EIN number instead. I think that's
no, you got to have a routing number to know what bank it came from.
That's true.
Yeah, you can't leave those numbers off. But you do not put them in the micro font, and you do not use the pre-printed checks that you normally get with the account.
Create your own.
Right.
Okay, but at this point, is it still that this closed account check is really only to be used on utility bills, or has that expanded?
No. It can be used for other things, but don't go there until I get all of this stuff ready.
Sure.
Wade has had good success, but they're also running into brick walls in the last month or two, so things are changing. And until we have a contract which forces Snow to honor these, don't think you want to go there.
Right. No, I asked because it sounded like it was going to be applied to other than utility bills on this week's messages, and I thought, well, that's the change. How is this kind of...
Eventually you'll be able to use it for anything you use the bond for.
Great.
But utility bills are the first place to start because they all have TT&L accounts,
right,
so they can directly handle it.
Right. Okay.
Yeah, I took the documents out of the folder until we're all complete here. It was confusing people, and we don't want any problems.
Do you guys have any idea on your time frame for figuring that out, or
as soon as I get this stupid contract written, I'm working on it.
It's on the list.
Hey, listen, we appreciate your efforts. I mean, I just
Yeah, well, thank you, but I've got to be sure that it truly is bulletproof and it doesn't leave any loopholes for Snow to leak out through. So it may be another week or so before it happens. Huh?
Patience is a virtue, right?
Probably.
I think so.
Yeah.
Thanks for your efforts.
Sure.
Hey, Louis, this is Mark.
Hello? Hello?
Hello.
Hi, this is Maria. I'm sorry, but the time when you were talking, my son was crying in reference to the administrative procedure, and I had emailed you a suggestion. What was the outcome of that?
The outcome of it is, yes, you can use anybody to receive the mail, and then they can just swear an oath affidavit before a notary that, no, they didn't receive any mail in your name.
And then that could be used just as the same, right? If it was a notary. Okay.
And somebody volunteered to type one of those up for us.
Oh, okay. And who was that?
I don't know.
Oh.
Somebody did. Was that you, Ed?
Yeah, I guess that's one of my volunteer missions.
Okay. Good.
Okay, great. Thank you.
But I got caught up on my paperwork, Louis, so hopefully next week I'll work on the contract for Snow with you as well.
Good.
Hello, Louis.
Yes.
It's Harry. Thanks for the email.
Okay.
Yeah, I was just wondering if you got any further along on getting the people in the court for doing illegal procedures, more so to speak.
Well, I think that's where this administrative procedure that I was talking about tonight would fit very nicely. We're going to use it against all of the people in Indiana that have been responsible for arresting Candy's son.
Here.
And we're doing each one in the amount of $50 million.
Yay.
Well, let me say that I have like several thousand people and several $1 million that we're doing an appeals and for judicial misconduct. and the paperwork is going to appeals court very shortly. And should I wait to do this stuff after they're found to be doing wrong, or?
Yeah, if you've got it that far into the appeals court, go ahead and let it mature out, and then we can do the rest of it later.
Okay, because the whole point of it is to get these people out of office. If that's possible.
Right.
Yeah, because there's quite a few.
No, the real goal is to so devastatingly bankrupt the government, they have to throw up their hands up and give up.
Yeah.
Okay.
And I don't know where I don't know where Hinkson came up with the $50 million number, but he pretty well justifies it. So that's what I have chosen to use for Candy.
Well, I think that's great you said that, because it is a very high number, and it's like earlier in some of our conference calls that people were putting too outrageous of a sum was defeating the purpose. But you're suggesting in this case it would not be so, and certainly that outrageous treatment doesn't, I think warrants it personally, but will the court honor it?
Well, in Hinkson's case, he filed a $50 million lawsuit against each of the agents involved in kidnapping him, and the court accepted it.
Wow. Has he been able to collect?
That was $50 million times about 6 agents.
Can I ask another question? If the appeals court rejects this, could I possibly take action then?
Sure.
Okay.
Sure.
Okay.
Has Hinkson been able to collect on any of that?
No, they have not brought it to a hearing yet.
Oh, okay.
They're trying to figure out how to get out of having the hearing.
Yeah. Well,
they have postponed it. Originally, they postponed it to April, and then they postponed it to August, and now they've postponed it to October.
What's the purpose of the hearing, Louis?
Well, the lawsuit.
But I thought he was using the private administrative process where the judge gave it a thumbs up.
No. He filed a standard civil lawsuit against the federal agents.
Oh, okay.
And that's what I'm saying is that in the normal course of affairs in a civil suit, he justified the $50 million sum per agent, and the federal court accepted it.
Okay, gotcha.
Okay, knowing that none of these agents are going to have $50 million, what do they do? Just settle?
Well, how do you know they don't have $50 million?
Well,
or that their corporation won't back them up through their bonds and other stuff.
Well, that's the thing. I mean, they are agents of the government, therefore the government is ultimately liable for the $50 million. Not just them, but also the government.
And again, if you get a $50 million judgment against a person in their private capacity acting as a government agent, that word will go out across the country, and every government agent is going to start treading a whole lot more lightly.
Yeah.
Yeah.
Okay, I have a question, too, in regards to who was it that was arrested and was telling everybody about their copyright, and, what about the people that, took their fingerprints and did all of that? It seems like they should be involved also.
Of course.
I've got all the agents' names. I'm going to go after all of them.
Including the clerks in the court that would, take your stuff and identify you and take your fingerprints and all that?
Yeah, all the deputies that were involved.
Yeah.
Liz, should I copy the sheriff on these, or just...
Sure. Sure, let him know what's happening. Let him know that his rogue agents are behaving outside of the norm and that you're going after them.
That's right. Beyond unprofessional, it's unlawful.
Right.
Okay, thanks.
And that will reflect back on him. If you get that claim against his agents, once again, it's going to reflect on the county. That'll affect his re-election. It'll affect the bonding ability of the county for them to borrow money. It's all a domino effect. You're not just spinning your wheels here.
I certainly hope so. Thanks.
Yep. Yeah, that's what we hope in Candy's case there in Indiana, that we can completely destroy all of the good old boys that are in power.
Absolutely.
And because we're going to go after everything, 2 judges, a couple of prosecutors, and right now the count's about 24 agents of the county and state.
And that, in my book, would be using the sword of the Almighty. No greater sword could there be.
Yes.
Yeah.
As a mother myself, I cannot imagine. Forget about it.
It's been tough to even think about it.
Oh, my God.
Well, I'm thinking, too, one of the reasons for us to move on all this stuff as quickly as possible before they move on all of this Patriot stuff, where they can pick you up. I mean, any of us could be construed as a terrorist and then spirit us away and nobody hear from us. You know? So
well, that's the purpose of Lewis's voluntary indenture contract.
Right.
So we can hopefully if we win one of those, they'll all be put on notice that they can't just whisk us away.
Right. Right.
Yeah, if we can all keep it, in contract and in voluntary servitude, then, we've got it. Because they can't undermine commerce. That undermines everything.
Right. And if we don't get satisfaction in the standard federal court, then we take it up to the Article 3 court, or further up than that if need be.
Then we go to the international court with genocide.
Right.
Genocide acts. Acts of terrorism. In fact, we could report it to Homeland Security. Terrorist acts.
Mm-hmm. Yep.
Are you talking about the World Court?
Yep.
Yeah.
And I would go straight to the Vatican with it, since they actually run the world.
That's true.
I never thought a few years ago I would be involved in something like this.
Neither did the rest of us.
No. Yeah.
Well, it's all over in about 12 months, so we may need to hurry up and do all this stuff.
Yeah, that's what I was thinking too. We don't have much time to fool around anymore. We've got a mission to perform, and we cover more of that stuff, the spiritual part of this, on the Project Eden calls on Saturday. And I'd really encourage you to listen to the one we've got tomorrow. There's stuff I got to tell you.
Tomorrow?
Yep, not tomorrow, Saturday. Yeah, at 1 p.m. Eastern Time.
What do you mean by there's only 12 months?
Well, if you kind of look at the propensity of the evidence, England came out about 3 or 4 weeks ago, one of their Regency boards, etc., and they published a study that the United States is $44 trillion in debt. We only have $45 trillion in collateral. So all of our land, all of our labor, all of our kids, all of our properties only worth $45 trillion. And debt's at $44 trillion. Going up $300 billion a month. You do the math. Okay? We're already bankrupt, but now we're totally insolvent again. The other thing you have to realize, 1789, 88 was when we got the first round of redemption. 70 years later, what happened? 1759 started the Civil War. 70 years later, 1929. Then 1933, the bankruptcy. 1999, the theory is we came out of bankruptcy. 2001, we went back in with September 11th. Now it's 2003, 70 years after 1933. Okay, we're here, folks. The biblical prophecy of 70 years for nation's redemption, we're here. It's going to happen. We just have to be prepared for it and know what we're going to do about it.
What's the it?
Well, we either come out of bondage and we get redeemed in the eyes of the Lord, or it's 70 more years of bankruptcy and bondage.
Okay, well, let's take the idea of the debt. I mean, that debt is because of their bogus idea of usury. Isn't it just as possible that the light will shine on the fact that that debt couldn't have been paid, so it's not there?
Well, the debt started 3,000 years ago.
Excuse me? Oh, yeah. Right.
Okay, but it's folks like us who are becoming aware of the issue that will help to lead the country out of bondage, out of bankruptcy, and find redemption, or we're cursed for another 70 years. The Bible says. But most people don't realize that 1999 through 2003 it's here. This is the time. Just like 29 to 33, 1859 through really 65, and of course 1770-something up through 1788, 89 when it finally all got done. Things happen faster now. What?
We have more tools to combat this now.
Well, we have the internet, and they want to shut that down pretty bad.
Yeah, eventually, with the electronic means of us communicating, will be shut down. So there's an important aspect that we do need to consider. Really getting serious about, and that's what the Bible talks about, the gathering. And when it talks about the place of safety and the army coming after the remnant, and all the verses imply that we're all going to be gathered together in one place eventually. So we need to start thinking about where that place is, and that's more what the topics are for the Saturday calls. So
this Saturday?
Yeah. Mm-hmm. Yeah, it's every Saturday, 1 p.m. Eastern Time. It's on the. I think the pin numbers. I'll make sure it's on the Freedom News Bank site.
Hey, Doug, I had a question for you.
Yeah.
To what level do you promote us recruiting people in?
People that you trust and you feel are being drawn. I mean, the people that are suffering and having foreclosures, I think God's intervening in their lives to wake them up.
Absolutely.
And these are the people that God perhaps is calling, and we need to help because we're called to serve. That's the whole purpose of our being given this knowledge, is to serve the others that are having the same problems. So,
well, I wandered around through a couple of different groups before I got here. I like this group.